how he got interested in this area of work. But what he does is he assists lawyers who are contemplating retirement or who are in the process of immediately retiring. Hopefully you don't wait until you're immediately retiring to use the information that he'll be giving you, how to monetize and make your law practice a saleable asset. So, Ed?
Good afternoon. So Alexander Abramson is a business law firm in Orlando, and we work with business owners on succession plans and exit strategies, among other things. And some of those business owners happen to be lawyers as well. I wanted to start off today by basically telling you a couple of stories that illustrate the importance of my talk. And the first occurred actually a couple of months ago. I own an interest in a business brokerage in addition to my law practice, and my partner in that brokerage, Matt, was contacted by a couple. They had run a small business for about 20 plus years, and they had decided that they wanted to retire. That business had provided them with everything they needed for years and years and years. It sent their kids to college and really had provided for them, and they were done. They were at the point that they wanted to travel and officially retire. And so they were going to literally close the doors on this business. And they told someone at church that they were going to close the doors. And this friend said, no, you've got to talk to Matt. So they went and talked to Matt. Matt showed them how they could turn around and sell their business. And it wasn't a lot of money, but they put an extra $120,000 into their retirement fund that they were basically going to let go away, completely disappear. And so that happened a few months ago. Also a few months ago, I had an estate planning attorney friend of mine. She came to me and we were at a meeting, and she said, hey, I just bought a building. I said, well, that's wonderful, fantastic. Tell me about it. Well, there was a retiring lawyer, and she wanted to sell her building. I told her I would buy it, and she threw in all of her client files in the process. Now, my friend makes probably a good couple $100,000 a year off of those client files that were just thrown in for nothing. I call it the BOGO plan, right? So buy one, get one free. She bought the building and she got the law practice free. Now, if you look at that couple $100,000, that practice was probably worth somewhere between $350,000, $400,000. So that lawyer, unfortunately, didn't get the benefit of it. And so I think it's important that we understand that your law firm is, in fact, a saleable asset. Now, when I raise that issue with lawyers, I get two responses. The first one is, those are pretty small type of thing, right? The first one is, you can't sell your law firm, it's not ethical. And the second one is, who's going to buy my law firm? I really don't have anything to sell. It's just a bunch of clients and referral relationships that I have. Now, I can understand the former, because the former arises because years ago you couldn't do that, right? The ABA adopted the rule that allows you to sell a law practice only in 1990. So I'm betting that when most of you in this room began practicing, it was unethical to sell your law practice. Now that changed in Florida in 1992 with the enactment of Rule 4-1.17. And we'll go into 4-1.17 in some detail later on. But effectively, for the past 26 years, you've been able to sell your law practice. Now, the second item, the second retort, is a little bit more difficult to respond to, right? And that is, hey, there's really nothing there. Well, if you look at it, technically, those lawyers are correct. There is nothing tangible there, right? But today, in business in the United States, most of what we have is all intangible, right? We don't have these big industrial giants anymore where their value is determined by the assets they have in place. Now, you may or may not have heard of a company called Salesforce.com. So Salesforce is a CRM software, customer relationship management software. It's used by the Fortune 500 and many, many smaller companies. they make gobs and gobs of money. So they've been on a tear buying different businesses. One of the businesses that they agreed to buy is called Tableau Software. And they do some, you know, data management type things. But I thought the interesting thing was here is that Tableau Software is going to be sold for $15.7 billion, with $1 billion. And yet their net income is actually a loss of $208 million over the past 2 years. And so what is Salesforce looking for? They're coming in and they're buying these intangibles. They're buying the client relationships. They're buying the in-place employees, right? They're buying the intellectual property. Now, these are all things that law firms have. They have client relationships, they have the employees, they have intellectual property. Now, I don't want you to walk away thinking you're going to get $15.7 billion for your law practice, because you're not. And I don't want you to think that if you have a law practice that's losing money, you're going to be able to sell that law practice. But I think this is illustrative of where we are today. Now, I think we have to have some fundamental assumptions that are here. And I apologize for the PowerPoint. It is missing some things. So I think when it got transitioned from ours to theirs, it got reformatted in some way. Fundamental assumptions. So the first thing that you got to have is a mindset. You have to understand and believe that your law practice is a saleable asset. Now, that mindset starts with the view of your law firm as a business. So your law firm as a business that provides legal services. It doesn't necessarily mean that your law practice, you don't practice in an ethical manner and that you don't follow the rules of ethics. But if you treat your practice as a business, that's the first step in getting to the point where your law practice is a saleable asset. Now, if you have a business that's consistently profitable, properly operated, and for which you've put in place an exit strategy, that business is saleable. And I know that it's saleable because I've done hundreds and hundreds of these transactions. There is one little gotcha, however. That is that most businesses that are offered for sale don't sell. Only 15% of them do. And so what's the difference between the business owner who wants to sell but can't do it and the business owner who can? That 15% is the key. How do you get your firm into that 15% to sell? So how do we get into the sweet 16? And now I can't even read that. So what are the assets of the business that provides legal services, right? We need to understand who are the prospects to actually buy your firm and why would they do that? What's going to drive the value of your firm? And alternatively, what could kill the value of your firm? What does a sale look like? What are the ethical rules and how do they impact your sale? So I think it's important that we have a fundamental basis for the definition of what a law firm is. A law firm is a set of people, systems, and tools that engages clients and that creates value for them. So it delivers results for clients. And for that, you as the owner receive a profit for your risk that you take in putting that together. And if we think about this, that's not different than any other professional practice, right? CPAs, doctors, dentists. And those CPAs, doctors, and dentists have been selling their practices for years and years. Now, these three things, people, systems, and tools, roughly correlate with the assets of your law firm. You have tangible assets, the desk, the computers, the chairs, the things that are there. These have very little value. You have the intangible assets, the client relationships, the team that you have in place that knows what they're doing, and also the systems, the forms and the procedures and the things that you do to deliver services to your clients. Now, if we break that down a little bit further, we see that the value here arises out of that intellectual property. And when we further drill down a little bit, we see those are, it's your trade name, right? Your relationship with your clients, your relationship with your referral sources, and your marketing operations. How you stay in touch with those people with whom you're in relationship. Now, when we look at selling a law firm, it's important to understand who the two types of buyers are that you will encounter. So first, you'll see that there are investment buyers. These are people who come in and look at your law firm as a return on investment. So they'll pay a certain amount of money and they expect a certain amount of return. This might be an associate that buys when you are retiring, or somebody from the outside that's coming in with the view that they're going to practice in your firm for the next 20 years and it's going to provide them with a good life as a lawyer. The other type of buyer is a strategic buyer. And what they do is they look at your law firm both from a perspective of throwing off additional cash flow, but also from the perspective of adding value to the current practice. An example would be where you have a family law attorney that purchases an estate planning firm. And so what they can do is now they can take their family law clients through the estate planning process as well and generate a higher fee and provide greater value to those clients. This is an important distinction to know how we're looking at your firm. Now, what determines salability? There's two factors alone. And that is how much money, what is the cash flow that's coming out to the owner out of that practice? And that's offset by the risk of that not continuing into the future. So if you've got great cash flow, but every year your revenue is up and down and up and down, that signifies there's a high risk. And that, unfortunately, hits the value of the practice very hard. So, the question is here, how do I make my firm attractive to buyers? And it's about reducing that risk for the buyer. Because when you see your practice, you are too close to your practice to really evaluate it. You've built it over some number of years. It's your baby, right? You live in it. And yet, when the buyer comes in, all they see is the possibility of that cash flow going away. So the idea is to make the buyer comfortable by removing those types of risks that we would have. Okay, so if a buyer can step into your practice and continue to generate income that you would have received, that is the perfect firm for the buyer. Okay. So what are some key law firm value drivers? First, consistent net cash flow. We don't want to see variations, substantial variations in cash flow. We want to see something that is pretty consistent over time and it grows over a period of time. If you have, unfortunately, what I see a lot of times, and business owners do this all the time, not only lawyers, but business owners, is things will be going great. They'll go on a tear, screaming, growing, and then the first sign that things slow down, right? So you see, oh, revenue is flat. Now that's time to sell. But that's actually the worst time to sell the practice, right? Because it's very difficult to sell as the practice is going down or as the business is going down. You want to sell on the upside. You want those 3, 4, 5 consistent years of growth in order to be able to show the buyer that, hey, this practice is working. Another thing that comes up often is client concentration. So if you have one client that produces 15, 20, 25% of the net cash flow from your firm, that's going to be a risk for the seller as well. Sorry, the buyer as well. Okay. Closely tied with net cash flow are financial records. This is what the buyer is going to gauge to determine whether what you're telling them is accurate or not. And those financial records are, you want to have them prepared by a CPA. You want something along those lines. A business broker that I know well, who specializes in restaurants, was called in to list a restaurant, a rather large restaurant. And the owners were great restaurateurs, but they were not great financial people. And they had, I think it was the daughter-in-law did the bookkeeping, and so there was a lot of questions on things. The tax returns weren't that good. So my friend went in there and he said, well, look, let's get you to a CPA. Let's clean this up. Let's make it look good. And let's operate this thing for 3 years. And after 3 years, I'll take the listing and we'll go ahead and sell it. And they were able to get 50% more of value out of that firm because they had good financial records. So I can't stress enough how important those are. And again, that's a risk factor that the buyer is going to be looking at. In our case, we have a lot of goodwill tied up in the individuals, in each of us. We have the clients know, like, and trust us. That's why they hire us. The referral sources know, like, and trust us. That's why they send people to us. And so part of the transition after the sale is making sure that you as the seller can transition all of that goodwill to the buyer, that you can let the buyer feel comfortable. So how do we do that? Well, we spend time after the sale closes to effect that transition of goodwill. Now, there's a reasonable amount of time that can occur over, and then there's an unreasonable. I just had a deal where the buyer wanted the seller to stay on for 3 years. That's a little bit much, right? But somewhere between 6 months and a year of making that transition isn't unreasonable. And then, of course, trade name. You know, the issue with trade name, obviously, is I'm not telling you to go out and create a trade name for your firm. Whatever your firm's name is, probably has some presence in the community. And the ability to continue that with the buyer is very important. So that also plays into that plan. So when we talk about law firm value drivers, I mentioned systems. Systems are really important in a firm because they enable the people in the firm who are adequately trained to move around. An example, a few years back, probably now 6 or 7 years back, I have a transactional practice. And so in December of every year, everybody comes in and they want their deal closed by December 31st, right? Anybody else have a transactional practice? Know exactly what I'm talking about? Right, I want to close this thing before December 31st. So you're always working. Well, shortly after Thanksgiving one year, my assistant, we're a small office, so we don't have a lot of backup people. My assistant came in, called me and said, hey, I'm in the hospital. I have pneumonia, and they're telling me I'm going to be out for most of the month. So that's a complete disaster for our office. And so my daughter, who was a sophomore in college at the time, had just finished her exams. And so I said, hey, you now got a job for this winter break. I don't know whether she's in the back here, by the way. That's my daughter, Brittany. So I drafted her into service, and the beauty of it was we had these written manuals. So when I said to her, hey, I need you to send this FedEx, naturally the question is, how do I send a FedEx? Here's the manual, and here's the tab for FedEx. And so we were able to put her in that position and have her functional in a very, very short period of time. And those components for your clerical staff are also things that you need to have for marketing. They're the things you need to have for your practice management system, right? It's all a written system. And that will go a long way towards making a buyer comfortable with your practice. They can see that it operates that way. The next one is what I call the herd. Throughout your practice and throughout your years, you will encounter a lot of people. There will be people who come in to meet with you who are prospects. Maybe they'd hire you, maybe they don't. If they hire you, they become clients, right? And then there are referral sources, people in the community that you know. And these contacts that you have over a period of time, you need to maintain. So I mountain bike, and I actually fell on my mountain bike and dislocated my shoulder. And so I was referred to a guy at Jewett Orthopedic. Now, I say a guy specifically because I have no idea who he is. He did wonderful work. I was very happy because I have full range of motion back and I can go out and mountain bike and do everything I want to do, but I can't remember his name. The same thing will happen when you represent clients. They'll love you and they'll want to send people to you, but they just don't remember who you are when you step out of their lives for any long period of time. And the way to get around this is to maintain that contact. So contact through an e-newsletter is a great example, although people are more moving now today into the printed newsletter area and getting it moving that way. So having that database of people that you can maintain a relationship with and then maintaining it on a regular and consistent basis is very valuable. I set up a corporation, did a shareholders agreement for these guys who are going to go create software, and which, we do that a lot. And oftentimes we never hear from them again, and these were the guys we never had heard from again. But a few months ago, they received a multi-million-dollar offer for their company, and we were able to represent them. They came back to us specifically because they said to us as they walked in, hey, we get your print newsletter, we love it. And that print newsletter is very low on law and very high on me, because we talk about, hey, where I've gone on vacation and put in recipes, and it's really kind of just an interesting read. So that's that. And then the team approach. As lawyers, we sometimes have this failing of wanting to be the hero, where we have to do everything. Our staff has to come to us for every question. We have to do everything at all. That mindset has to change in order to be able to sell a practice, so that your clients view your legal assistant, your paralegal, as resources that they can go to directly and probably get quicker answers than they get from you. And so that begins by bringing them into that conversation, having that team approach. So we have value creators, now we have value destroyers. And I know this is going to sound like, hey, wait a second, it's the flip side of the same coin. Undocumented systems. Well, when I talk with people about systems, oh yeah, we got systems. Sally knows how to do everything in our office. Sally's been here 20 years. She's perfect. She runs runs the entire show. And so, the problem is that Sally also plays the lottery. And so when she wins the lottery, she's never coming back into your office again, and your systems are all gone, right? And so that's obviously a key issue, is making sure that. The next is unreliable financial performance. So if your revenue is up and down and all over the place, you got to look at that firm as being at the lowest of the revenue levels, because it is all over the place. We talked about playing the hero. One of them here is getting burnt out. We encountered one lawyer who wanted to sell her practice, but unfortunately, she had begun referring cases out in her main practice area to other lawyers in town, and stopped getting a normal flow of clients in. And so she said I needed a break, and I wasn't gonna take on those cases. And so the problem was she has effectively diluted the value of her practice. So we have a resource here for you, and that is a 15-point law firm salability checklist. You can go and download that, and it'll give you a checklist that you can apply to your firm, and print it out, do it as you please. When you sign up for it, you get into our little mailing list, and so you can get out of it right away. But you can also see how we're contacting people, how we're staying in touch, and we call that a follow-up sequence. So when somebody asks for information from us, we provide the information, and then we have a follow-up sequence. And after that follow-up sequence, they get into a general communication. So it's just something to take a look at. So yesterday, I attended the CLE on giving CLE, which was quite interesting, right? And one of the things that they said to do, and I think I agree with it, is when it comes to adult learners, the worst thing you can do is just tell them everything, right? So I don't want to tell you everything today. What I would like to do is I would like to take 3 minutes. We're at 3:57 right now. I'd like to take 3 minutes. I'd like you to pair off and to talk about, of the value drivers here that we just talked about, the value drivers, which you think are the most important or that you could implement in your practice right now. So let's take 3 minutes. One person goes for 1.5 minutes. The other person goes for 1.5 minutes. And let's start now. So please pair off.
I don't know.
96.
And just to step in here, because I know that some of you are on the phone, just talk to yourself. You're not going to be able to pair off. While I have you on the phone, I do want to give you a little bit of information, and that is to you and remind you of what the CLE course number is for this course. It was on one of the slides before we began. I want to give it to you again, so you can write it down. CLE course 3216. That's 3216. Good job.
So if you haven't already switched, the other person should tell what they think is most important. Yes. Oh, okay, great. Okay, go ahead and wrap it up. You got about 10 seconds. All right, everybody. Okay, so if I could get your attention. So what I'm gonna, nobody has to do this, but I'd love for somebody to volunteer to share what they thought was the most important thing they got out of that. Anybody? Yes. Oh, I gotta get your microphone.
I'm probably going to have to repeat it for the policy. Awesome.
Thank you very much. My name is Maria Antonatos, and I practice in Broward. I live in Coral Springs. I work in Miramar, Florida. 3 people in my group. And I understood the question to be which of those 4 that I think were the most important, the key long-term value drivers. And I went with the consistent net cash flow. I'm not referring your case to that because that would effectively devalue the firm, as you covered. And also, instead of doing the books yourself, it would be very important to hire a very good accountant or CPA firm and make sure that all the I's are dotted and the T's are crossed and all the paperwork is in perfect order. And in that way, it'd be ready to sell. Now, Britt also had some very good comments.
I don't own a law firm yet, but I would agree, consistent net cash flow, number 1.
2 excellent points. So 2 things about that. One is if you're doing your own books, you're throwing money away because you can hire somebody to do your books for 75 or 125 bucks an hour or less, and your hourly rate is a lot more than that, I guarantee you, right? So 100%, you should be hiring somebody to do your books who is qualified. And great, consistent cash flow. So we had a question. I'm sorry, I didn't get your name. Question, yeah, you came up. Jeff asked a great question, and he said, well, so tell me, what are the metrics of valuing law firms, right? And when we look at consistent cash flow, you're going to take all of the benefits that you get out of a practice. So it's somewhere, take your salary, take the net, take the auto that it provides for you, take the travel to the Florida Bar Conference and the time you spent on the beach, even though you were supposed to be in CLE. Add all that in, and then you multiply that by somewhere around 2 to 2.3, right? So 2 to 2.3. So all of the net benefit that comes out to you, then that's rule of thumb, right? So what's a rule of thumb best for? Measuring thumbs, not law firm value, but it's a rule of thumb. So to give you an idea of where you're at in that process. Now, one question that often comes up is, hey, what about like one times revenue or something like that? And I don't like using one times revenue as a valuation provider. I don't like any revenue numbers. We use them as checks, as sanity checks. But I don't like using them because if the firm isn't run well, if it doesn't produce enough cash flow for the owners, then it could be generating great revenue, but it's still not worth much, right? So always look at, we call that FTE, all of the benefits that flow out to you. We call it seller's discretionary earnings or adjusted net earnings, one of those two. Anybody else?
John, your excellent financial records, I think, are important, but I do some transactional other professional practices. One thing that I know that business brokers look at in their values is consistent pattern. What's the projection line? Usually as we get older or you get tired, you're going to hit a peak and then you're probably, I'm not really going to work that hard, so it's going down. So you want to probably be selling at a level status more on an upward projection, not when you get tired and you're not coming in as much or you're not driving as hard.
So Jeff's point was that it's better to sell when the firm is growing revenue rather than flat, although flat's possible, but certainly not when it's in a downward sloping revenue. So your revenue last year was greater than your revenue this year. That's a bad thing for purposes of selling a firm because then you're having to tell the buyer a story about why you're slowing down and why this is going on. And so that really is a great segue into the idea of, hey, I need to do this an extended period of time in advance of when I think I'm going to sell. I've got to get my firm ready because the sale process for your average business that's properly priced and properly marketed is somewhere between 6 months and a year with kind of an average of about 9 months. Superstar firms will sell very quickly. We've had a couple that have sold in 60 days because they had great financials, they were in a market that people wanted, and they were screaming along. But you can't expect that to happen. And then you've got to make some of these changes we're talking about months in advance of when you want to sell, years in advance preferably. Okay? Anybody else want to add?
I just have one question. If you're in let's say you're in a firm and there are 5 partners, and you're all in there working, and you want to retire, and you want to take your book of business and spread it amongst the other partners, and they want to apply. It's the same metric apply within a firm as taking the whole firm and selling outside of the firm.
So Jeff was asking, and I'm reading it for the people that are remote here. Jeff was asking, what if I have partners and I want to take my book and sell it to my partners? How does that get valued? And it's a little bit different because you're spreading the overhead, and there are different ways to spread the overhead of the firm. You can spread the overhead on a per capita basis, so each attorney pays their pro rata share, or you can spread it on a gross revenue basis. So attorneys with the higher books pay more of the overhead. And so that would be the factor that is going to play into that. The other side of selling internally, because that's what we're talking about as an internal sale, is you got to look at what your shareholders agreement says currently, right? Or your operating agreement if you got an LLC, because that may restrict you on how you're able to sell your book of business internally as well. Some of them, unfortunately, some shareholders agreements actually facilitate or actually encourage somebody who's nearing retirement to leave because they have a very modest payment to an attorney who's leaving. And so in order to get out from underneath that, the attorney has to go to a different firm or start their own firm and look to sell their book and do it that way. Okay, so let's talk about ethical issues, right? Okay, so I mentioned earlier, Rule 4 dash, I like to walk around, so now I keep remembering to myself, hey, the microphone's here or nobody's going to hear me, so sorry about that. I mentioned before, the primary rule here is 4-1.17. And one of the things that it says is when you sell a law practice, right? So what is the sale of a law practice? Well, clearly, if I am selling my law practice to somebody who is outside the law practice and they're going to come in, so they're not an owner, they're certainly not inside the practice at all, that's most certainly a sale of a practice. What isn't the sale of a practice? Well, clearly the situation that Jeff talked to us about, where he is selling his book, or the question that he raised, selling his book to his partners. That's not a sale of a practice, right? So we have two different pieces. The question comes in where we have, okay, let's bring an associate on for a period of time as my partner, and then eventually that associate's going to buy me out and I'm going to leave the practice. Is that a sale? Isn't it a sale? I take the position that if the ultimate goal is for you to leave the practice and that's the only reason that you're taking on the partner, then that's a sale and you have to follow the requirements of Rule 4-1.17. Now that might be a conservative approach and you might differ with that, but I think that's probably the best approach to take here. Now, I think we've kind of been hopping around a couple of topics here, but it's important to understand what a sale looks like, right? So there are really two flavors of sales. There's the equity sale, and then there's the asset sale. So in an equity sale, we have attorney seller and attorney buyer. The transaction is between the attorneys, not between the law firms. So attorney buyer gives cash to attorney seller then transfers stock in the PA to attorney buyer. And then attorney buyer now owns the law firm and goes off and runs the law firm. So that's that setup that you see on the screen. In an asset sale, it's a little bit different because the transactions are between two law firms. So attorney buyer forms a PA, and that PA and the seller's PA do the transaction between themselves. So the assets of the seller PA, the intangibles, the client relationships, all of that transitions over into the buyer PA. And then at the end of the day, the seller PA has cash and maybe a note, right? Because most of these transactions, the seller does hold paper in the transaction. And then the buyer law firm goes off and does its own thing. So that's the base structure that we're looking at here. Okay? So here are some of the rules that we have to be cognizant of. Law firm sale. So if we look at the law firm sale, there's a structure that's laid out in 4-1.17. The first thing we have to do is we have to provide a notice to clients. It's got to be sent certified mail, return receipt requested. It's got to notify the clients that there is a pending sale, that they have the option to opt out, and they have the option to retain another attorney. So they can go off and do that. Now, if you get the green card back, and you don't hear from the client, the assumption is the client is willing to go along with the sale. If you don't get the green card back because you don't know your client's address, that's a really bad thing, right? You don't get your green card back, then you cannot include that file, that matter, in the sale. And then at that point, you are having to withdraw if you want to retire, because that matter will stay with you. It cannot go to the new attorney. And then, so obviously, the need there is to maintain the relationship with your clients, right? So we have to know who is a client. So the best practice there is to use written engagement agreements, right? Written declination letters and written file closing letters, so that we don't have to send notices to past clients. We only have to send notices to current clients. So once the matter is done and you've closed the file, you no longer have to provide notice there. An issue comes up with due diligence. I think I'm probably skipping ahead here. Okay, we talked about at least 30 days prior to the closing. So we have Rule 4-1.17, proposed sale, right to retain certified mail, and then consent is presumed if no objection is received. Now, if they object, then you have to go through the motion to withdraw. If they do not communicate with you and you do not have proof that you provided them with the notice, you have to go through the process of withdrawal. Okay, so an issue comes up with this because, and I actually have talked to lawyers who had this problem, right? So they had the practice sold, they had a contract with a buyer, they sent out the notice. The day before the closing, the buyer said, I don't want to do this. So now all the notices have been sent to the clients, so the clients all know that you're selling your practice, and your buyer just walked away. So my question to that lawyer was, how much of a deposit do you have? Unfortunately, it was zero, right? Zero. So what 4-1.17 is making you do is take a deposit, complete all of your due diligence, make sure this is a deal that's going to happen before the first notice goes out to the client. And then from there, the money that's on deposit is a non-refundable deposit. So that if the deal doesn't close for any reason on the buyer's side, at least you've got some money that you can go back and reestablish the relationship with the clients. We talked about who is and who isn't a client, and then how easy is it for you to give notice. So this is, I don't suggest that, I don't get any money for making these referrals, but I think you should go and use an electronic case management system, because this should be able, you should be able to press a button and generate these letters through your case management system. This should not be an arduous undertaking in any event. So in the process, right, we do due diligence. So what happens is we have a buyer. The buyer wants to make sure that what you've told them about your practice is true. And so what they do is they go and they look and say, okay, well, do you have that kind of gross income? Do you have this number of clients, right? They go behind and analyze what you have. So we have rules of confidentiality, 4-1.6. And we have to maintain client confidentiality. And if you look at 4-1.16, they have a special circumstance when it comes to sales of practices. And they equate it to you bringing on a lawyer into your firm. If you were to do a conflicts check with a lawyer that you were doing a cross transfer or hire or that, you can provide the identity of persons and entities that are involved in a matter. You can provide the summary of the general issues, and the overall purpose is to detect and resolve conflicts. You cannot provide disclosure of your matters if it would prejudice your client, of course, right? Or any details, like significant details about the matter, unless you get your client consent. So as a practical matter, what I say is, and oh, by the way, this only has to happen when there's substantive discussions. So as a practical matter, what I say is, look, you can do an initial due diligence with a blind analysis. So instead of Mrs. Jones, Mr. Smith, we have client 1, client 2, client 3. So we don't identify anything about the client. We identify what type of matter it is, and maybe we identify an opposing party. I don't think you need to get that far at the first stage. Then when there's a contract in place, meaning you've agreed on the terms, and you've got what you need to have in place for deposit, then you go through this balance of the due diligence process. Now, one other thing that's a little bit unique about this, right? In normal businesses, you don't have any obligation as the seller to check out the buyer. But in our world, you do. According to Rule 4-1.1, you have to make sure that the buyer in your practice is competent to handle the matters that you have with your clients. You can't change the engagement agreements once you sell your practice. Those engagement agreements, I, as the buyer, take those on and agree to fulfill those, right? So whatever the scope of representation is, whatever you have in that agreement, I'm obligated to take on. So you, as the seller, must be sure that I have the capabilities to do that, okay? Then we talk about how do we pay the seller, because we know that there are some restrictions on sharing legal fees, right? Inside of a firm, we're pretty good, right? We don't have a lot of restrictions on how we share legal fees. Outside of the firm, there's pretty substantial restrictions on how we do that. And so if we're going to buy, and we just set the price, okay? And then the buyer is going to pay that price out over a period of time. That's an exception to the rule requiring lawyers splitting fees, for the most part, be in the same firm, right? The problem comes in if you're expecting to be compensated for future revenues, because those future revenues aren't a price that's set today. It's a price that's set based on what happens with those matters going forward. And so in that case, we want to keep an of-counsel relationship. And it needs to be a bona fide of-counsel relationship, not of-counsel in name only, right? So that as a member of the firm, you can continue to split fees. That also helps, as we said before, with transferring the goodwill to the buyer itself, or himself or herself. And interestingly enough, in the area of non-compete, so Rule 4-5.6, you can have a non-compete. If you go through the process of 4-1.17, so you provide the notice, do everything you need to do, then there's a comment, the third paragraph of 4-5.6, that allows the seller to enter a non-compete agreement, restricting them from practicing, which normally would not be the case. So a lot of times people look at the question of, do I close down or do I sell? And one of the things that we've noticed in the process of doing this is that those processes are pretty closely aligned. A lot of the work that you have to do to sell your firm is similar to the work you have to do to close down your firm, because you have to provide notice to clients. You have to go through the withdrawal process. Now, the problem with closing down a firm is that you stop taking matters, but your expenses continue long after the time you stop taking matters. And so you're constantly funding the firm as things are winding down, right? So what do you have to do? If you're closing down, you've got to notify your clients, you have to transfer matters if you can, withdraw, right? You got to reconcile final bills, pay the lease, right? Complete the lease, sell off the assets, do all of those things. It takes as long and may be more expensive than actually selling your practice. And this, right? So closed down, I built this firm for 30 plus years and all I got was this lousy t-shirt. So, there you go. All right. So, salability boosters, so things that are going to help you, right? We're going to talk about intake and case management systems. So again, software is going to be helpful here. The intake system, a word about taking on matters, right? We talked about referring matters a little bit ago when I talked to the story about the burnout. The thing is this. You don't necessarily want to, don't want to keep all matters, right? You want to keep matters that are in your specialty with the clients that you want to be serving. and you want to be referring out all those others. And your intake system should help you do that. We want to have that client database for the herd that we talked about, the client, referral source, all that, and we want to have those marketing materials. All right, so I have a sheet with some helpful links here. I put up the law firm salability checklist before. There's a link, you can go download that. The bar rules, a list of bar rules that are applicable to sale or applicable to closing down. We have a list of those. That's rules, dash, and dash exits. And these are all bit.ly URLs, shortened URLs. And then we have the book, a guide to selling a Florida law practice, and you can download that as well there. Okay. Any questions? Yes. Can't hear you.
My question is regarding non-compete agreements, and you touched upon it. As part of the sale, typically there's a non-compete agreement with other sellers, or sell my firm, with bargaining from certain behaviors, things like that.
Yeah, so non-compete agreement in Florida, there's a statute that permits non-compete agreements because they're non-enforceable to common law. So we have the statute, and so if you follow the requirements of the statute, then it's enforceable. And typically, it would be a non-compete for a particular geographic area, so you wouldn't be able to practice law in a particular geographic area. It could also be that you wouldn't be able to practice law for the particular clients that you're transferring, right? Or maybe it's practicing law within a specialty that you've transferred, one of those. So that's typically the way it would look.
I'm normally opposed to that sort of thing, so it caught my attention. But I'm also thinking that the person selling is going to be retiring anyway, so it would be not for my thinking.
So, and that's true. If you're retiring, a non-compete isn't a big deal, right? And it always raises a red flag when we're representing a buyer and the seller says he's retiring, and we provide a non-compete, and they say, no, I don't want a non-compete because that doesn't exactly match. But you know what? So, because the issue you also raised was, hey, I'm not in favor of non-compete agreements, right? And I would say that given what we talked about in the beginning about this being mostly intangibles and goodwill, truly the only way to protect those from the buyer just going back into practice again is through that non-compete agreement. The example I give in my normal practice is, look, you know, would you buy a cleaners if you knew that the owner was going to go 2 blocks down and set up a new cleaners, right? Of course, nobody would do that because they're buying that element of relationship, and that's the only way to protect it. Any other questions? Yes.
I came in late, if you've answered this, I apologize. I'm a solo criminal defense attorney. I own the office and everything in it, but I cannot imagine my firm having any value when I walk out the door. I mean,
We did exactly answer that in the beginning. So no, that's good.
Can you explain? I mean, I get paid 99% of the time flat fee in advance.
Right.
So I'm obligated to see that matter through. I cannot imagine. In my mind, I'd have to pay somebody to take the case.
Yeah. So the question is, hey, I'm a criminal defense attorney. Why would anybody come in and buy my firm, right? And that was what most of the hour was about. But that's okay. That's all right. But the bottom line of it is that you have. I don't know how you get your business, but I'm sure you've got a reputation in your community. So you have a reputation in your community, right? And you must have a process for getting that business, right? So that has value. The way that you practice has value. And so, yes, yours is probably one of the more difficult ones to sell, as opposed to like an estate planning practice, right? Those we can sell all day long. I don't know. Some of my friends who are criminal defense attorneys say they have recurring clients, so I don't know. So So in your case, though, it would be about that marketing system that brings in those clients on a regular basis. It'd be about your goodwill in the community. And there might be a way, and I don't know the particulars about your practice, but there might be a way for us to enhance that so that there's value there, and then we take that value. And that's kind of the succession planning process, is taking what you have now and moving it into something that may be more valuable because we focus on some of those things.
Well, wouldn't something like that, perhaps you can sell the access to the phone number or to the information?
That's a perfect example, the phone number. If that's an example, or a website that produces, constant inquiries, right? Those are things that are part of your marketing system that have value as well.
Yes, I've been in business for almost 30 years. And 2 years ago, I had an associate who I find out later always had like the mens rea to go into a firm, who's been duly established, and literally steal your clientele. Address, phone number, email. So she's not even admitted in Florida, she's admitted in another state. So I filed a bar complaint against that attorney in the state. That state, it was like, well, it happened in Florida and we're not gonna do anything about it. I'm like, what? So I have to sue me kind, but clients were coming to me and said, what's this? I get an email from this girl who used to work there and I've never met her.
So what protects it? So I guess the question is, hey, if an associate, well, so from an ethical standpoint, the client's a law firm. But I think the question, right, is how do I protect against somebody coming in and stealing the clients out from underneath us? And we can't have non-compete agreements, right? So except in the sale process, we can't have a non-compete agreement. So we're prevented from doing it that way. So what we kind of backdoor it, right? And we backdoor it by making sure that you are the star, but not the hero of your firm, right? So the firm is about the relationship with you. And then when your buyer comes in, it's the relationship with you and your buyer. And then eventually you fade out of the picture and it's the relationship with the buyer, right? If you've ever looked at a large company, they buy, right? A large company will buy another company. They'll merge the two trade names. So it'll be one trade name and then the other. And then eventually the old trade name will go away as it's absorbed into the larger company. And that's kind of the same scenario. You are your unique asset for your law firm, and you're going to market yourself. But that doesn't preclude you then from bringing somebody else on and marketing with them. But by doing that, you limit, I shouldn't say prevent, you limit the ability of someone to come in and just swoop in and steal a client base from underneath you. Any other questions? Thank you very much.